Hello, this is a presentation from Family First Legal Mediation and Collaborative Law Firm. This is a quick tip on types of evidence you may want to gather and use for family law matters. Please note that this is for educational purposes only and not intended as legal advice. If you would like legal advice or a consultation with an attorney, please give us a call or contact us or reach out to a local law firm in your area. Evidence is one of the most important pieces of putting together your case. As a matter of fact, you don't have a case without evidence because all you have without evidence are your allegations, and allegations alone will not stand. So here we've identified four types of evidence. And the first type of evidence we have here at the very top is documentary evidence. Documentary evidence is just like what it sounds. It's documents. These are physical documents that you're going to provide to the court in some format in order to show the court something that's either written or a report that's been provided. This might be a police report. This might be a report card for your child. This might be copies of documents from the school for your child. It might be a copy of an agreement that you and the other party have signed, or it could even be documents or pleadings in your current case. It might be an order from the previous time that you and the other party have been before the court. So all of these things could be documentary evidence, and these are very important because this gives the court not only something to look at and read, but it will be supportive of any testamentary evidence. And so that's the second type of evidence we're going to talk about, testamentary. That is where someone gives a testimony. It's a witness. It's usually you or the other party or someone that you or the other party has brought to court to give a vocal or verbal testimony about the incident or the things that you believe will matter in this case. Documentary evidence is supported by verbal testimony generally. So generally you'll have someone who's testifying about something and you can show them the document to help them refresh their memory, or you can show them a document to have it entered into the court to show that what they're saying matches up with what's on the document. This can be very important in proving to the court that the person who's speaking is a truthful person. It gives two types of evidence that the court can look to find corroborating or supporting evidence for your arguments. This is going to be important. Documentary and testamentary evidence are two of the most important pieces of evidence that you're going to use in a family law matter. And consider when you're asking people to become witnesses for you, whether they're credible, meaning whether they're someone who will come off to the court as truthful, whether they speak well enough to be understood by the court, and whether they are knowledgeable enough about the facts of the case to be able to testify and answer questions not only from you, but from the other party. And then you want to consider whether you need an expert witness, someone who can come in and testify based on their expert knowledge, their education, their background and experience, that the point of view that you hold is the point of view of that party's community. For instance, if you bring in a scientist or a therapist, the therapist can say, based on their knowledge and based on their review of your case, that your point of view is one that is supported by therapists in that area. This will be very meaningful to the court. If the court qualifies that person as an expert and an expert agrees with you, that will be very weight heavy on the court's decision as to whether your side of the argument wins or loses. So an expert might be something that you want to consider. Not every family law case requires an expert, but it is something to consider. Now, the other two pieces of evidence or two types of evidence which are listed here are not used so much in family law matters. Those are tangible and digital evidence. So tangible evidence is that evidence which you can bring into the courtroom and show the court something that has an impact on the case. This is usually something you see like in criminal law matters or tort law matters, for like car wrecks or things like that. So someone might bring in a gun. This is the gun that was used to shoot down however many people, or this was the knife that was used, or this is front the front fender of a vehicle that was damaged in the accident, and this shows the impact. So in those types of cases, tangible evidence is more important. But in family law matters, generally you can bring in documentary evidence that's going to meet the same need that you would have to bring in a tangible piece of evidence. So where you might want to bring in an item, you could bring in a picture of that item or a before and after of that item. The only time I would recommend bringing in a tangible item is if you, in your opinion, or you and your attorney in your conversations have decided that this piece of evidence would be something that would definitely persuade the judge that the damage that was done to this item or how this thing was treated has a huge impact on your case, then maybe, but I think that's going to be the very rare instance. An example of using tangible evidence in a family law case might be if you're trying to get a divorce and you're trying to decide who owes whom and what type of property belongs to whom, and you're separating property. In that situation, you might have family heirlooms that have been passed down to you. Those aren't typically marital property. You're going to get something from a great great aunt or a grandmother or a grandfather who gives you something, and that item is in your home and the other party causes damage to it or sells it and you obtain it back and it's damaged. In that case, you bring the item into the courtroom, you show the court, this is what this item looks like now. It's worthless. It doesn't have the value that it had when I received it as a gift. And this is a picture of it before, and this is what it looks like now. And you're showing the court how destroyed the thing is. So it might be that you had a vase, and the vase in the picture looks very beautiful, nice, and it's worth a lot of money. And you may even have an expert testify to how much this would have been worth. But then you brought in a bag of broken pieces that represent the vase. That might be something that the court is interested in seeing, just because it shows the condition of the vase is in such an array that there's no way you would ever receive value for that, even if you try to put it back together. However, I'd still say this is the rare instance, and then even having pictures of the shards of the vase might be better than having the actual thing there. So tangible evidence generally is a no in family law cases. Digital evidence, it's kind of a toss-up there. I would say anything that you have digitally, that would be like your text messages, emails, photographs, you might even have those digitally. That also may include videos or other digital things that you might have, like social media posts, things like that. So videos, you can't print a video out. Videos have to be digital. So there's pretty much a very limited way in which you can display that, and you would need to make sure you just have the appropriate TV or monitor present in the courtroom on that day in order to show your video to the court. And that may require you to reach out to the court in advance, contact judges' chambers, and determine what method they would like for you to present the video in. But my suggestion is, if it's not a video or something that requires additional digital technology like a voice recording, if it's a text or a social media page that can be printed out, print it out, make it documentary evidence. With text messages, you can generally download a program that will let you download all your text, or you can possibly request it from your phone company to have them print out all of your text. There may be a cost associated with it, but it'll be worth it to have that documentary evidence that you can actually give to the court. And you have to remember that in family law cases, you're not before a jury, you're before a judge. And because you're before the judge has limited time. The judge may or may not have knowledge of how to use digital evidence or not, or how to access digital evidence. But with documentary evidence, that's very easy for any judge, whether they're savvy with digital technology or whether they're not. The paper is going to speak for itself and allow the judge to go back and review it in chambers if they so desire. So my advice is that when possible, turn digital evidence into documentary evidence. And this is why I say documentary and testamentary evidence are going to be the most used pieces of evidence in your family law case. Now, this has been a quick tip and a general overview of evidence in family law cases. This has been a presentation of Family First Legal, mediation, and collaborative law firms. If you've enjoyed this presentation or would like more information, please check out some of our other quick tips that are already posted or that will be posted soon. If you would like a legal consultation, please reach out to us. You can reach out to us on our website at www.fflmd.com or on social media at Family First Legal. Thank you.